welcome everyone, and thank you so much for dialing in on an evening. We're going to have quite an interesting session to share with you this evening, and we certainly hope that it will be beneficial to you as both investors or as curious persons who want to know about conflict avoidance and dispute resolution. So my name is Bernard, and currently I'm actually consulting in the fintech and cryptocurrency space. There's been quite a lot of activity, of course, here in Singapore. But I also am quite passionate about investor education. And so I've linked up with Waypedia and with Conhow, and we've organized this event. Hopefully it's interesting for you. Now, to this evening, we have a very distinguished guest, Mr. Anil Changraroth. Anil is, of course, a practicing lawyer, but what's really interesting is he's also a mediator, an arbitrator, and an adjudicator. Now, what's the difference between these three? Well, you'll have to listen to what Anil shares later on, and hopefully you'll get to know the difference between this. But it is all in the name of trying to, we were trying to get to a point where it's not, avoiding costly litigation and going through the courts. Anil will share with you, what the court system is and what are then some alternate methods of avoidance and or dispute resolution. Anil, of course, is, as I said, a practicing lawyer. He's an advocate and solicitor of Singapore since 1995. He is also a solicitor of England and Wales. And one of the sectors that he's been quite active in is in the infrastructure building and construction area, for which there, as you can imagine, there could be some disputes arising as well. So he comes with a great wealth of knowledge, and we're really excited to have Anil share with us this very interesting topic on, avoiding conflicts and also on dispute resolution. So Anil, over to you.
Okay, thank you very much, Bernard, and thank you, Kun Hao, for hosting this webinar. So exactly as Bernard said, I really these days I go by the term instead of calling myself a lawyer, I usually go by the term conflict avoidance and dispute resolution practitioner. And to those who are not familiar with it, it can come off sounding like a whole new world. And, Bernard mentioned that I sit as a mediator, adjudicator, and arbitrator. So what I'm going to be doing in the first 20 minutes or so, 20 to 25 minutes, is just to give you a quick run through of what this is. Now, my slides are also in a note for in a PDF form where you can actually, it's hyperlinkable. So once the Kunhao sends that out to all of you, when you're going through the slides, when you click on each of those things, like for example, my name, my chambers and all that, and some of the examples I give you, it'll take you to the various websites that will give you a little bit more information on what we have. Now, once I'm done, what we want to do then is this, to get into a Q&A. And during the Q&A, I understand that many of you are involved in the investments and all of those kind of things. So we'll talk about the kind of problems you face there and the kind of disputes you face there and how you work around it and how best to tackle those things. And I'll give you some examples of live cases that I've been involved in with the financial sector as well. And then we'll take it from there. All right. So essentially, this is what.
Sorry, Anil. Sorry to interrupt, but just to everyone out there, Conhao has sent a link. There will be a link that's sent through. You can actually invite your friends. This is a free webinar, so by all means, if you think any of your friends might be in, as an SME or individually in a conflict situation and could benefit from this webinar, by all means, right now, use the link and invite your friends, right? It's a free webinar, so invite as many of your friends as possible. Okay, sorry, Anil, for interrupting. Over to you again.
Okay, so basically, I'll be covering these areas. Just a quick point about the state of the COVID-19, a brief overview of court system, right? And then talk to you about what consensual and adjudicative methods of dispute resolution are, then go on into a little bit of online dispute resolution, then into collaborative contracting. While the examples I give you on collaborative contracting are the construction industry type of contracting, it is the concept of collaborative contracting that I want to get out to you, and how you can see that work possibly in the industries that you're familiar with. And then I have one slide on consumer and financial institute dispute resolution. I want to show you what Singapore has, and then make some concluding remarks. Okay, right. So dramatically disrupting the COVID-19 has been considered as a dramatically disrupting work and society and how it functions. Social distancing resulting in greater use of technology, for example, in communication. The courts and dispute resolution institutions are moving away, as a result of that, are moving away from traditional forms of dispute resolution. Not just forms, but also the platforms on which you work. So, for example, in the last 3 weeks or so, I was in a mediation where my instructing solicitors were from Italy, the clients were from Spain, and we were in a district court here in Singapore, or before a judge mediator, right? Again, 2 weeks ago, I was in a family mediation where my instructing solicitors were from India, my wife client was from India, and we were all also on Zoom. So the courts have all started to go online with a lot of the things, and I think in Singapore we are headed to far more disputes being dealt with online. Now, when I say Singapore and far more, I'm referring to within the court framework. But today I'm going to be talking about how you can get your matters resolved without having to really go to court, right? Then I will talk about virtual hearings. So you realize that virtual hearings are becoming a commonplace, right? In the Q&A, we can talk a little bit more about that, because whenever people talk about virtual hearings and disputes, they kind of think about whether or not artificial intelligence is a key element, but it's not, all right? So I just want you to understand that. There is a far greater and wider adoption of online dispute resolution mechanisms. And so if you look at the top right, you see my chambers, you see an international consultancy, and you see something called ODR Asia. That is a company that I've just incorporated a couple of weeks ago, and we can talk about that in the Q&A if you want to as well, if time permits, all right? So a brief overview of courts and litigation. Generally, the courts are there available for you to deal with any of your disputes, all right? And traditionally, not traditionally, the jurisdiction of the courts are that the state court are matters that are up to 250,000 are dealt with at the state court, and matters that are above 250,000 are dealt with in the Supreme Court, right? And again, like I mentioned in the notes that I sent out to you, those are hyperlinkable, so it'll take you to straight into that. Okay. Now, a lot of people would consider litigation a costly affair, right? But actually, it really depends on which jurisdiction and where the courts are, right? In Singapore, you find that the courts move very fast. So if you start a case in the start of the year, there's nothing stopping you from having the matter disposed of before the end of the year. So it's the time scale is you're looking at matters do not take more than 12 to 16 months to resolve in court. But of course, you have a whole court's fees and preparations that you undertake. And you realize that at the end of the day, it is a judge who makes a decision. You have no choice in that. And that's what litigation is about. It is not within your power. It's within the court system, and the court decides. So there is an element of fees and how much it's going to cost. And a lot of people will then ask the question, why do I need to litigate? Why do I need to go to court? Are there other avenues of resolving the disputes? And this is where what we're going to be talking about comes into play, right? Critically, you have to appreciate there are two forms of dispute resolution. There's one that is consensual, and the other is, I'll come to that in a while, but consensual, what it means is this: the parties themselves have control over how they come to a resolution. The parties themselves decide how the matter should be settled. And all they have is a third party assisting them or guiding them to that settlement, right? So, for example, you have something called conciliation, a neutral third party helping the parties to arrive at a negotiated agreement or a settlement, right? Or you have negotiations themselves. So before you enter into an agreement, you obviously get into an interactive communication process where you share the information, bridge the differences, and you come and enter into an agreement. So that's a form of consensual conflict avoidance or dispute resolution for to make it. It's a term that all encompassing. When I'm talking about consensual, you have this thing about conciliation. You have this approach to entering into an agreement, which is negotiation, and you have mediation. Now, many of you may have heard about mediation in an extensive way in Singapore, especially because 2 years ago, Singapore was the venue where the United Nations Convention on settlement of enforcement of mediated settlements was signed off on. We had 56 countries here in Singapore signing on the convention, and it's now in force as of 12th of September last year. What is mediation? Mediation, again, is where the two parties come to an agreement and they sign off on an agreement. They're guided by a mediator who facilitates, and in some jurisdiction, the mediator may take an evaluative approach to trying to settle the matter. And an evaluative approach means that the mediator will give you some reference, some guidance of where he think it might go, right? So now in a private mediation, the private mediator will only facilitate. But in a court annex mediation, that means through the court system, the court would have matters go to mediation as well. And in that system, the judge mediator, right, the particular judge would have some form of evaluativeness. He evaluates the matters to some extent by telling the parties, if this matter is going to be heard by me in trial, which I will not be because I'm sitting here as a mediator, then I want you to appreciate that chances are this evidence is not going to work, that evidence is not going to work. So you may want to think about it in the totality of things and see whether you can come to a resolution, right? And like I said, it's facilitated by a third party who does not make decisions, right? So this Friday, I'm going into a mediation where it involves two parties on one side and about 5-6 parties on the other side, right? Both represented by senior lawyers. But at the end of the day, and it's a particular issue of the law, and I don't need to know the law on that area. That is not my job as a mediator. I'm just there to consider whether or not the parties can move away from their respective positions, look at what the interests of the parties are at the end of the day, and come to a settlement that would help them move along and carry on functioning in their business environment or as friends or whatever, right? So that's what mediation does at the end of the day. Right? I mentioned the Singapore Convention. It facilitates international trade and promotes mediation as a viable option to resolve trade and disputes. It provides an enforceable mechanism in which parties within the signatory countries can enforce it. Okay? Now, at this point, I think it is also important to take note that very often when you talk about consensual dispute resolution mechanisms such as conciliation, mediation, or negotiations, people tend to think of the word not binding, right? It's not a binding form like in a court judgment or in an arbitration award, so to speak. But what you need to know is this. When you come to a settlement, parties just simply have to enter into an agreement. And once they enter into an agreement, that is binding in nature because it's a contract. Of course, parties may breach and all of that, all right? So keep that in the back of your mind as well. The word binding and the effectiveness does not apply. And what the Singapore Convention does to mediation is what the New York Convention does to arbitration. And arbitration is a whole different regime. All right. Now let's then talk about adjudicative methods of dispute resolution. All right, is where a third party makes the decision. Right. So that's why the third party adjudicates. Right. And that's why in America, all of these methods of dispute resolution are all broadly defined as adjudicated or adjudication, right? So sometimes the term adjudication may be used differently in different jurisdictions. In America, it means any kind of settlement. Going to trial is adjudication, going to mediation is adjudication, and all of that. Now, this adjudicative method of dispute resolution, some of the examples are neutral evaluation, where you get a neutral party to evaluate both parties' cases and give you recommendations. the parties can decide whether or not they want to be bound by those recommendations, or they use those recommendations to negotiate a settlement. So remember, the consensual approach of negotiation I mentioned can be a second step after you get someone to neutrally evaluate. Now, expert determination is where you get an expert in the field to come and make a determination as to whether or not who is right and who is wrong. Now, in the construction industry, you may need a defects expert, a delay expert, and all of that. But in the financial situations that you guys are familiar with, you may need a financial expert to come on board. So it could be, let's say you have a deal with a broker, and it is highly technical. The aspects of the defects or the defaults that the broker had committed were highly technical in nature. It doesn't really stem on the facts of the case between you and him and what transpired, but it's a very technical details. You can choose that you want an expert, another broker from some other company, to come on board and make a determination whether or not technically who's right and who's wrong, and whether or not a broker can be held responsible. So herein lies an example of how you can not go to court, but have the parties decide, listen, do we agree that this issue that we have with you and how you traded, overtraded, or whatever on my account, it's all technical aspects. It's not about the facts of the case and what I told you and what you told me, but how when you did the trading, it was technically wrong. Can we agree that we're going to have this matter decided by an expert? Can we agree this is the particular expert that we want to use, and then move along that way, right? And that's what expert determination means. Okay. You have then this is very broad. Actually, you can read this on your own. Internationally, there's something called a dispute board. It's really in the construction industry, but it doesn't mean that you cannot bring it into a financial industry and have a similar situation. What a dispute board does is this. So let's say you've got a construction project that it's 3 years. You decide that your dispute resolution must be done through the method of dispute boards. You hire people to maybe either one or three people on board from the start of the project, and they monitor the project. And every 3 months, whenever the contractors and subcontractors have an issue, they put those issues together in a summary, and the adjudication or the dispute board will make recommendations or decisions on whether who is right and who is wrong. So, for example, I'm now a sole adjudicator in a project that's taking place. A foreign company is building something in Jakarta, and on that project, they're using an international form of contract. The international form of contract has got dispute boards as the mechanism for resolving disputes, and I'm the adjudicator for that. So that's what it means, right? So these are some examples on international, and it's mainly construction related, but it doesn't mean that it cannot be applied across the board if you think about specializing a dispute board format or a framework for the finance industry. Okay. You can take a look at some of these examples as well. I don't have to go over that. Now, adjudication is another method. It's also specialized as particular in construction industry. And as a result of that, in Singapore, for example, we have an adjudication regime, and we've had that since 2005. And the result of that is that a large percentage of construction disputes don't go to arbitration. They just go to adjudication. It's a quick method. It's just a method where you present your documents, present your submissions, and adjudicator just makes a decision on who's right and who's wrong. Okay, so that's adjudication. You have a contractual adjudication, and you have a statutory version of that. Then you've got something called a conflict avoidance board. This is just before it becomes a dispute, and this is an interesting concept. You can read about it on your own time. It is also by agreement between the parties. They decide that whenever there's an issue, not a dispute, you can see whether or not it can be resolved by a team of people on board, right? So it's just an option. You can read on it on your own time. Next, I wanted to speak very briefly about online dispute resolution. The idea of online dispute resolution is that all of the dispute resolution mechanisms are put online. Meaning, like I give you the example of the client I have in Spain and the client I have in India. The mediation in the State Court of Singapore is all held online. So it is just basically the platform on which you do that. Okay, and it's called online dispute resolution, right? So there are protocols, and since last year, it's been in a major way. It's come on board. that a lot of matters are going to be resolved on this platform, as I mentioned. Okay. Again, you can go take a look at some of these examples. The International Chamber of Commerce have reported on what online dispute resolution is, and when it started and how it works and functions. There is, and I was part of this working committee, the Asia Pacific Economic Cooperation Framework and Model for Procedure and Rules for ODR. And it's basically a cross-border B2B disputes, right? Business-to-business disputes, and how you can resolve it without physically having to go to a particular country where the fault, the defaulter is. Instead, you can bring it on an online platform, and the parties come. Of course, parties must agree to come on it and all that. All right. There are some other guidelines on this. You can take a look at that on your own as well. So the idea, now that I've talked about dispute resolution, I just also wanted to share about this thing about collaborative and alliance contracting. In the construction industry, there is a great move towards making contracts more balanced, not risk allocated to a particular party, but far more balanced and sharing of risk. And some of the examples internationally are here in my slides. I just wanted to give you a hint of it, right? And think about it for a minute. When you come out of the COVID-19, a lot of the industries and a lot of businesses just want to move along, and they want to carry on with their businesses. They can't afford to point finger at each other and hold each other responsible. They want to just move along. And you find that the world over, especially in the construction industry, people are moving away from this risk that is totally allocated to one party, the subcontractor, as opposed to the main contractor, but sharing the risk. So I just want you to appreciate that there is this thing that's happening around the world. And then some of it is also called relational contracting. So if you, again, on my notes, if you go and click on it, it will take you to the site that shows you and explains what this is. So now, let's say, for example, you are in a financial institution and you are part of an institution that's working a dispute resolution platform and how you want to have your matters resolved. You may want to talk about all of the things that I've talked about, negotiations, mediations, and all those things, and also may want to draft a contract that is more balanced between the parties, getting into this relational contracting, so to speak. And truth be told, if you're an investor and you're working with a broker, it's really a relational contract. And so why would the contract be set in a frame that parks the risk all totally to one person as opposed to sharing? Of course, I agree with you that when you talk about the fact that the broker is the expert in the field, and therefore he must carry some of the burden and some of the risk. I agree with you on all of that. There's no denying that. But there's nothing stopping for the relationship to be set in a clearer framework, in a more neutral framework, so to speak. Okay. The last aspect that I wanted to share was this. In Singapore, you have the Financial Industry Dispute Resolution Center. It's called FIDRAC, right? And there, where you have a dispute where it involves financial institutions or financial services, meaning a financial product or service, or advice about a financial product or services, and they call it FI, right? Financial services provided by to individuals and businesses. And if there's a dispute, you can take it to FIDRAC to get it resolved, right? But of course, it's only claims up to 100,000, and it sets out a process of mediation. So mediation, and if it cannot be decided by mediation, parties cannot come to a resolution on their own. They then have someone adjudicate on it. So it might be an interesting site to go take a look at, especially if the disputes are here in Singapore. But if the disputes are not here in Singapore, then you want to maybe consider the framework that there is and then take it from there. All right. So to end off, I told you I'll take about 25 minutes or so. What you need to appreciate is that the potential for change is unlimited and bound only by our imagination, for better or for worse. So if you're talking about disputes and you're talking about problems that you have, you just have to appreciate that it is not necessarily, oh no, I got to go to court with this. It's not necessarily that. I've just given you a quick rundown, a quick idea of what the world can hold. Right? In such a situation, you don't talk about contracts, you talk about equity, you talk about justice, you talk about what is the right thing to do. So, coming out of the pandemic, this is something that our Minister of Law had mentioned in April last year. So think about it that way as well. when you have a problem now and coming out of the pandemic, you don't want to take it to task. You want to sit the party down and see whether or not it can be resolved by some method of dispute resolution that is more accommodating to both of you, and it's really takes away your position and takes you to a position, or takes you to where your interest lies, and try and solve that. All right, and that's it for now. I know it's a quick run through. That is why I have my slides in a handout form, and it's got links that will lead you to where it is. And you have to appreciate this. I lecture the Building and Construction Authority Academy on ADR, which is Appropriate Dispute Resolution, and it's a full day course, and that full day is still not enough, right? So can you imagine? I've just covered in half an hour, giving you an idea of where you don't have to go to court, but you can really go to a whole lot of other avenues. But yes, you have to accept the fact that parties must agree to it, right? But there is really no stopping the parties from wanting to resolve the matter without it having to be blown out of proportion, right? Or taken to task or in court as well. All right, over to Bernard, and we can take questions and all of that.
Okay, thank you very much, Anil, for that great sharing. I don't know about the rest, but my eyes have suddenly been open to some new avenues of resolving disputes, and even for conflict avoidance, right? I think in the past, all we thought about was if there's a dispute, it's to the courts, and it's really, really expensive. As I said, I do work with some fintechs and startups, and inevitably, certain relationships don't go so well, and there are also disputes that come up as well. Perhaps some of you who are listening in, you are running your own business, or people who are either even large corporates or SMEs in dispute situations. So I think what Anil has shared this evening certainly gives us some very good ideas and handles as to some alternative mechanisms we can use. And I'm sure Anil is more than happy to be available even after this, if any of you think of any scenarios or you want to reach out, right? But for now, I have thought of a number of questions which maybe makes it a little bit more practical. And I'm just guessing that perhaps in the community out there, these are some situations, practical situations in Singapore that you have encountered. So I've got a couple of questions for Anil, and anyone who wants to ask a question, by all means, use the Q&A chat bubble and type in your question even as we are conversing. But the first question I have for Anil, simple one. You mentioned mediation. So, could you bring it to a bit more of a story level? Tell us a story of a mediation that you've done which was successful, and what were the success factors?
Okay. So I do this quite often internationally when I speak to mediators and when I train mediators as well, right? So I give you an example that I had a client who came in and there was a $3 million claim against him, and he came to me and he says, I don't really have that much money. A claim to him meaning a lawsuit in the High Court of Singapore, right? And he said, I want this to be mediated. I've heard about mediation. Can we settle because they say it's cheap? That's all he knows. I say, yeah, mediation is a process. But I told him this, you are at ground zero. You've got a claim that is about 3 million against you, and you're at ground zero, right? So because you're in the court system, you're going to have to file a defense and counterclaim, right? And come up to being on par with the claimant. So once he gave me the full set of instructions and I analyzed the matter, I realized that there was a counterclaim. So we filed a defense and a counterclaim in court for about $1 million, right? So the difference now is about 2 million. So we're going to court often because in the High Court, you have these things called a pre-trial conference and so on. So we kept going back and forth, and I got to know the lawyer well. And then, one day we were sitting on the sofa while we were waiting for the registrar. I said, hey, I just tapped her on the shoulder and said, hey, mediate lah. Then she went, oh yeah, that's a good idea, right? So the next thing we know, we were in a mediation with 2 mediators, and we started the day with a difference of 3 million. By 3 p.m., we were at a difference of 300,000, meaning that the claimant only was willing to accept 300,000. My client looked at me and said, let's walk. Then I pulled him aside and said, I told the mediators, give me a minute. I pulled my client aside and I told him, I said, can you just make an offer? You worked really hard on this matter. You gave me detailed instructions, and I really don't want you to suffer at the end of the day. Then he asked me, he said, how about your legal fees? Then I said, my legal fees is very simple. If we walk out of this mediation now, we will go into 8 months of preparation for a trial. I would probably bill you close to 100,000, 200,000 in legal fees. At the end of the trial, I'll still be a happy man because I would have got my fees and you would be still nowhere. And it's a third party making a decision, not within your control. So make an offer. Then he said, okay, go ahead. I don't care. Just tell him 80,000. Right? It was a ridiculous sum, 80,000. And lo and behold, the plaintiff agreed to settle at 80,000 in 8 installments. Right? Of course, you must remember one thing, the plaintiff's decision on that also stems on the fact that I had a defense and counterclaim that could possibly succeed in court as well. So they had to weigh that thing as well. So my client signs off the agreement with the plaintiff to pay by 80,000 in 10 installments. And my client looked at me and he says, I still don't get it. You just lost 200,000, potentially $100,000 to $200,000 worth of legal fees. I said, to me, it's very simple. You're going to go off, tell 4 of your friends what I did. One of them is going to come to me in a period of 2 months to 3 months, and depending on the legal work, 20,000 or 30,000. And the 4 of them are going to tell another 4 people what I've done. And in that 8 months to 10 months period where I potentially could have had 200,000 in billings, I may be able to bill 100,000, 150,000, and potentially have about 12 clients. So to me, it's not rocket science. To me, it's conflict avoidance and dispute resolution practitioner. All right.
Okay. Yeah. Thank you, Anil. And on that, with that, my reflection is, I would say Anil is probably one of the rare lawyers that I've met who has ethics. Okay, just by what he's saying, right? I've dealt with quite a number of lawyers in my day, and you have all sorts. So it's really, really refreshing to meet someone like Anil who thinks in that way, and it's not just thinking about his fees, but thinking about the ecosystem, the greater good, and conflict avoidance and all that. That's a really great thing. Thank you so much, Anil. Now, my second question is, some of the audience here, they are active traders, some are maybe not so active. But in Singapore, there are also foreign brokers who have set up, or some of them may open accounts online to trade equities, bonds, etc. The question I have is, what happens if, let's say, something happens, a pandemic, disruption, and any of these brokers whom we may place margin funds with go down the tubes, they are insolvent, and we still have funds held with them, and they're not releasing to us. That could be a dispute, a very real dispute scenario that may be encountered by some of our audience here. Now, in a situation like that, what are your thoughts in terms of dispute resolution along the lines of what you've shared?
Okay, so the starting point is this, right? You must appreciate that all the financial institutions and then brokers and everybody else, right, have got reserves kept with the MAS. Their requirements that they must keep certain fundings and all of those kind of things. So that forms the recourse for anybody who goes belly up, right? Now let's take, when you say foreign brokers and all of those kind of things, it really depends, because it's a company that's incorporated in Singapore, right? And therefore it's an entity in Singapore. And because it's financial institution related, there is a guarantee, so to speak, of a certain sum that's kept with a certain party. So that therein lies that safety net, right? Now, when I talk about private limited companies, let me just give you a quick example. If you incorporate a company and you're a director of the company, director and shareholder, one of your biggest concern is whether or not you're personally liable, right? And the answer to that is very simple. If it's a private limited company, the liability of the company is not your personal liability unless you sign a bank guarantee or so on. So you're not personally liable. It's always about the company. So if the company is, let's say, for example, registered or paid up capital of 100,000, that effectively means that they've got $100,000 worth of assets. But when a dispute arises, it doesn't necessarily mean that there's 100,000 left in the bank that you can take. Not that way. It's all of the assets together. So it could well be a case that when you decide to sue that company, it becomes a company that's worthless because there's no money for you to recover. So it's like squeezing blood out of a rock, so to speak. Okay, so let me then just give you an example. I had a matter where I was acting for a private banker, right? The investor was from England, and he sued the bank for my client's overtrading of his accounts. My client overtraded the accounts by 250 times or something like that. Okay, and it's a long story. So what happened is that the investor sued the bank, and the bank convinced the investor to bring my client as a co-defendant in the matter, and saying that my client had fraudulently overtraded the account. Now, there was some truth in that matter because my client had actually overtraded the account like no tomorrow. And in his sorry state, he had even sent emails to clients saying, I'm very sorry, but I've got cancer. I'm suspected of having cancer, and therefore, please allow me to blah, 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 and made a whole lot of excuses. So all of this came out, all right? But what happened then was this. I had to put up a massive structured defense. And part of the defense was the fact that while I'm a private banker, I was working as an employee of the bank, and ultimately the bank is responsible. So that's where my defense lies. So, in disputes, right, you must have a case theory or a game theory. And my case theory was that I was still working as an employee of the bank, and ultimately the bank was responsible. Okay? So eventually what happened on that matter as well is that we went to mediation, right? And my client in a 6-hour mediation session, my client had all of 6 minutes with the mediator. That's a different story. I mean, I have a whole lot of I've got articles and then essays written on what my views are on mediators who do that kind of thing, but that's a different story, right? So my client had about 6 minutes of mediation time with the mediator, but the investor settled the matter with the bank. Okay, then we still have a case against us. So to get us out of the case, I just told the bank, sorry, you pay. And eventually what happened was that the bank had to pay us to come out of the matter, to settle the matter and close it up, because the bank had settled with the investor and they didn't want to go out with it. Now, obviously my client at the end of the day still lost about 30,000. He lost his license and so on. But 30,000 and losing the license was a small amount to pay for potentially a claim of 2.5 million or something like that, right? And he was at fault at the end of the day. He did overtrade, he did lie and all of those kind of things. So coming back to your point about how you deal with matters, point number one, the entity, whether they're a foreign entity or not, are registered here. There might be some security that they have, right? But if they do not have a security and all of that, you can't get anything out of them. You just have to appreciate that, Of course, there's some other angles as well. Sometimes the parties have a judgment in court and all that. Then they'll come to me and says, "Oh, I want to go and take his bank account." Then I say, "You know his bank account?" No, I don't know. But you lawyer, ma, you should be able to find the bank account. Then I said, "Okay. So for this advice that I'm giving you now, I'm going to bill you 5,000, and I'm going to call up your bank to get your bank account number so I can take the money from your bank account. Are you okay with that?" "No, how can?" Then I said, "So your bank account, you won't give to me, and I can't get from the bank because you won't allow the bank. But when you have a case against someone else, you expect me to be able to get you the bank account number." It's not rocket science. It doesn't work that way, right? So you have to appreciate at the end of the day, there might not be monies available for you to recover from. Then you're in trouble. So like now, you have a lot of construction companies that are going belly up. There's no money there, and people are given a fraction of what they are owed, right? But you really can't keep saying, "No, I don't care. I want all of my money." So there is this technical aspect of the legalities and how you go forward, but there's also this practical aspects of what you can and cannot recover at the end of the day, depending on what's there. All right, Ken, how's that?
Okay, great. Thank you very much, Anil. I think that brings a lot of clarity, and I am quite sure some who are listening in the audience now, you're connecting the dots with people that you know, because construction and property is quite a big thing with a lot of Singaporeans. So hopefully that gives us again some handles. Now, on the subject of property, let me just switch gears a little bit. to rental disputes. I'm aware that quite a lot of Singaporeans do own investment properties. And especially now during COVID times, or some of the tenants may lose their employment passes or lose their jobs, et cetera, and that could lead to rental overdues, rental not paid. Some are truthful, some are not truthful, and I have personally seen dispute situations around rental. So what have you encountered in Singapore around the area of rental disputes?
Okay, so the starting point is this. If you have a fixed term contract, say let's say you have a 2-year contract, right? There usually a diplomatic clause that says that after 18 months, in the event that you have to pack up and leave the country, you can terminate the contract. You're allowed to terminate the contract and give it up. But otherwise, let's say you entered into the contract on the 1st of January 2020, and it's till the end of this year 2021. But you're really struggling now and you want out now, right? Truth be told, you are still liable for the remaining 6 months. You can't run away from that. Okay? Legally, the landlord is entitled to recover the 6 months, but he must mitigate the 6 months. So let's say the rental for the 6 months is 5,000 a month. But if he secures someone who for 3,000 a month, the difference that he's losing is 2,000, and therefore his claim should only be 2,000 a month for the remaining 6 months. But he has a right to claim. Okay? Now, of course, again, we come to the practical side of things. The practical side of things is very simple. How do you recover money from someone who doesn't have money? So you can commence court proceedings. You can sue him, and you can get a judgment that says, he has to pay you X dollars, but he may not have X dollars, right? But now, again, because of the uniqueness of rentals and all those kind of things, right? There are sometimes you can go in. And if you're the landlord, you can go in, it's called a writ of possession. But you have to go to court. You can't go into the dispute resolution mechanisms that I suggested. You go to court and you get what is a writ of possession, and you get to go and repossess. So let's say you have a machinery there. Your tenant has machinery there. If you take a writ of possession, seize the property, you can effectively take all of the equipment, sell it off, and recover money from there. Okay, so generally that's the issue about tenancy. But let's look at it the flip side. I had a very small case some long time ago where after 3 months, my client realized that whatever the landlord had promised is not going to take place in a 4-story building, which was a shopping mall. My client was promised how the 4th floor was going to be a cinema, and her booth was just next to the escalator, so there was traffic and so on. 3 months later, she said she found out nothing's going to happen, and she wanted out. Of course, she's supposed to pay the remaining 21 months of rentals, so she came to me. But interestingly, this lady had very detailed negotiations that she entered into when she entered into the tenancy agreement, and she gave me those details. So effectively, that gave me enough ammunition for a 7-8 page letter of demand against the landlord on misrepresentation, meaning she was induced into entering into the agreement on promises, and once she had entered into the agreement, she realized that those promises were false, and therefore she suffered damage. Right, and lo and behold, after about 3 weeks, the corporate lawyer, who was the landlord's lawyers, picks up the phone and say, "Hey, Anil, I act for the landlord." No, and I say, "Yeah." He said, "Shit, I saw your long letter. How? I don't want this to go any further." Then I said, "Easier, let my client off." Then he went, "So you're saying that if I let your client off, she won't claim the damages and all those kind of things?" I said, "Yeah." And my client walked away without paying the remaining 21 months, right? So the bottom line of that is to share with you that, you actually have to do a lot of hard work as a client. If you have enough details in your information, in your storyline, we can then pitch remember I told you the case theory or the game plan. And in this, what I did was I went under the point on the law of misrepresentation. And whether I'd succeed in trial, that's a different case. But I had enough to make the lawyers on the other side go, oh God, this is going to be too much of a struggle, too painful. Let's just let him off, right? Kind of thing. So I hope that helps you with some of the points on tenancy agreement. Ken?
Okay, thank you, Anil. What fascinating legal stories. I think I can sit the whole day listening to all of Anil's war stories. Okay, we have a question that has come from Kat Lai, and Kat Lai's question actually is
blockchain
blockchain and all that. So Anil,
an interesting story on that. I defended a young 22-year-old army guy who had convinced his platoon sergeant to give up his bitcoins worth 300,000 and that he said got lost in the dark web. All right. And it was such an interesting case because when the boy first came to me, he was a national service boy and I thought, okay, it's a simple case of a criminal case that I would try. And I quoted him a price. And then lo and behold, he tells me the story of this bitcoins and how it works. I know it's not blockchain, but it's a Bitcoin portion of it, right? I'll come back to the blockchain part in a minute or two. And he was so detailed. And after that, I said, so where did the money go? Then he says, oh, lost in the dark web. Then I said, but then he says, oh, but I want to pay it back. Then I said, huh? You want to pay back 300,000? You're a national service boy. He said, yeah. They said, where are you going to get money? They said, sell the house. I said, whose house? He said, parents' house. I said, don't talk rubbish. Then he said, anyway, I got money in the bank account. Then I said, money in the bank account? How much is that? Then he said, I've got 190,000 in the bank account. I went, what? Because he had learned how to trade on Bitcoins since he was 12 years old. And he has been trading for a long time and he had that kind of money. Of course, that money was frozen in the end of the day. And we went to trial and we clearly showed the fact that my client didn't personally benefit and all those kind of things, right? To me, the prosecution really couldn't show beyond reasonable doubt that my client was guilty. But, in Singapore, sometimes, whether beyond reasonable doubt is very subjective and how they work. And in the end, he got convicted. He went into detention center, not total prison. He should be coming out soon, I think, right? But he gave us, everybody, the judge, the parties, everybody a massive education on Bitcoin and how it works, okay? So now let's look at blockchain. The fundamental of blockchain is basically a secured system that's encrypted and every document that you have is encrypted and safeguarded and all that. So when you talk about a case involving blockchain, I suppose it can fall either under crime, where fraudulently someone has cheated you and told you that we've got the system that's secured and blah, 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 and it wasn't, and then you ended up pumping money. But it doesn't necessarily have to be blockchain. It can be any bloody scam that somebody is getting caught into, right? But specifically whether blockchain has caused construction, like let's say, for example, you have smart contracts that you develop through on a blockchain platform and use that contract, and the contract caused you a problem. Whether or not you can hold the blockchain company responsible for that and all, it's a little quite tricky for things. So the simple answer to your question is that no, I haven't had many issues on blockchain claims and disputes, right? There's another one that says private. If someone invests, can you see that?
Yeah, I can.
Yeah. Fabian says,
I'll just read it out to everyone. And this is from Fabian. If someone invests in a fraudulent company selling bottles of wine as an investment that fails, the delivery of the bottles that did not happen, what can be done to recover the money? Okay, I think that's it.
Now there are two parts to that as well, right? One is that this is just a contract that you entered into and you never got delivery, right? And I'm very sorry to say that in a matter like that, you'd have to go to court, because if you pick up the phone and say, can we mediate? The other guy is going to say, huh? And not bother. Oh, can we adjudicate? Anil has told me about neutral evaluation, expert participation. Let's go and settle it that way. They're never going to come to it, because this is clearly a case of the party refusing to pay or took you for a ride. All right. Now, of course, you then have to go to court and commence court proceedings for the recovery of the money that you paid out. Okay, that's one. Now, when you say fraud, if you can show fraud is a very tricky and tough threshold. But if you can show that you had fraudulently been induced into entering into that agreement, there is a criminal element to it. And you can make a police report, and if the police investigates and they decide to prosecute their guy, that is a far more serious crime, a far more serious issue than just going to recover the money from him. Because if we recover the money, he doesn't have money, he doesn't have money. If it's less than 10,000, you can never make him bankrupt. If it's more than 10,000, you can make him a bankrupt. But if he doesn't have bank accounts, he doesn't have checkbooks, he doesn't have credit cards, he can live his life as he has always been, even if he's a bankrupt, right? So when you ask a question like this, there are two elements. One is a criminal element, and the other is a just contractual element of a debt recovery, right? So you got to look at that. But if you know the person particularly well, and you know that he's fearful of criminal offenses being brought against him, charges being brought against him, then you can try the avenue. Now, again, when you make a police report, I'll tell you 90% of the time, the police will tell you it's a commercial matter, go to commercial court. But if there's a clear evidence of the elements of fraud, if you come to a good lawyer, he can formulate enough of a criminal charge and bring a private prosecution in the state court. And the guy would have to appear, and if he doesn't appear, arrest warrant can be issued against the person. But you really need to know whether the elements of the crime are satisfied in that case. Okay, so it's quite tricky.
Okay, great. Thank you, Anil. And in Anil's profile, there's this other interesting element where he's also been, used his expertise skills in family conflict situations. So now switching tracks again out of commercial and financial. What about in family conflict situations? My question actually, is to maybe just dwell a little bit on the conflict avoidance principles. Okay. So, we talked a lot about dispute resolution, but perhaps now we can think a little bit about pre-dispute. So, are there, from your experience, mediating and presiding, are there rather conflict avoidance principles you could suggest to the audience here?
Yeah, so they are. So okay, so let me just start off by telling this that I didn't mention. 90% of commercial matters that go to the state court for less than 250,000, 90% of them go to mediation. And of the 90% that go to mediation, about 80% of that are settled at mediation. So that is what you call a court annex mediation. So the court system has that. The High Court doesn't have annexed mediation, but they will send you to the Singapore Mediation Center to attempt mediation first. All right. Likewise, in divorce matters, mediation is a step that you must take. It's a requirement and it's set out there. Okay. So mediation has been in the family court system for a while now, but there are also other systems that are formulating. One is called oh my God, I forgot. I think it is called collaborative practice or something like that. I can't remember the exact terms, but there are two other terms being canvassed now. A collaborative practice is where the lawyers come together and they cut a deal before even it goes to trial, before it goes into dispute, before even commence proceedings as well, right? You can have that so there are these practices, and a lot of them are turning to that. And the High Court in Singapore, one of the judges who leads the divorce matter, had coined a new term. I'm very, very sorry, I can't remember what it is. And it's an attempt to make sure that the parties are not confrontational, right? And so there are clear approaches and platforms available at resolving the divorce matters in an amicable way, and it can be done, all right? So it doesn't really have to go to a fight. But you see, the trouble with divorce matters is that it's very personal. It's personal, and they just want to go for blood, right? I mean, I give you a silly example. One party cheating on the other. They know it. They don't need to use that cheating as a ground for divorce. There's grounds of divorce called unreasonable behavior. Yet they will pay $3,000, $4,000, $5,000 to an investigator to watch over the wife just to confirm, or the husband, just to confirm what they already know, but they never use it. And then yet they go to a lawyer, and when the lawyer was trying to do a good job at a slightly higher price, they say, "Oh, so much, so expensive." But they forget that they already spent 3,000 to 5,000 for a job that's not necessary. But why? Because personal, ego, attitude, personality, right? So in matrimonial matters, a lot of the times it's really personal, and it can get tricky that way, right? But there are avenues in place for mediated settlement, and a lot of parties do have their divorce matters settled early in time. All right. Someone also asked whether how good is a verbal agreement? Simple. You spit on your hand and your palm and you shake hands. There's a contract. Okay. A contract is a contract as long as there's these elements of offer, acceptance, consideration, and intention to enter into an agreement. I will give you 6 bottles of wine. You pay me $100, right? And this is a deal we want to, and there's a clear intention. It's a word of mouth, right? And I pay you the money and go on. All right. So verbal contracts, yes, can. Of course, in the construction industry, if you want to go by the method of adjudication, you can't go down the path if it's not in a written agreement. Okay. So I've had a matter where someone had claimed, I think it was an illegal money lending or something like that, right? And it was about 50,000 or 60,000. Right. And there was no evidence that money was given and so on. And I remember I was a junior lawyer and I was assisting a senior lawyer. And when we went to trial, right, we thought it was a slam dunk that the other party had no evidence, no documents to show that he had given the money and all kinds of funny things. Okay. And we thought we were going to win and our client is going to walk away easy. But lo and behold, we went in there and the judge called up the lawyers into the room and said, I don't think the plaintiff would have gone through all this trouble for a scam to get back 50,000 from the defendant just on a scam, right? It looks like there must have been some deal between the parties. So defendant's lawyer, I'm suggesting to you, you go out there and talk to your client. We can go through the trial today, but it does look like there was something here. So maybe you want to talk about to your defendant client and talk and see whether or not you want to make some payment and settle this and get rid of this matter. So we went out and we turned to our client and we had to tell the client the story. The client looked at us, but you told me that the plaintiff had no evidence, no documents, no nothing. So it's a sure case. Then we looked at the client and said, honestly, you tell me, you don't have to give us the answer. But honestly, let me just ask you something. So you're saying the plaintiff never gave you any money, is it? You don't have to answer. You don't have to answer because I'm acting on whatever instructions you gave me, right? Because if you now tell me that you did take money, then you'll be lying and I have a problem. I'd have I'm conflicted out and I have to get a discharge from acting from you. But you don't have to answer. But honestly, tell me, this 8 months of struggle then coming to court, he never took any money from him, is it? And next thing we know, our client made an offer and settled. So verbal agreements, if you have the details of it, it could be by communication. It could be by WhatsApp. Say, yeah, okay, agreed. Here's the money I deposit. Because people don't go and put money into somebody else's bank account just for free. Right? So yes, you can. Verbal agreements, yes, not a problem.
Okay, thank you, Anil. There is a private question that's come in as well. And it's around, fees and costs, right? I think that's a very relevant one. For mediation services, what are the range of fees and costs that one could anticipate or expect vis-a-vis litigation costs? Could you give us a sense of the difference?
Okay, so let's say, the client I told you that 1 million and 2 million difference and all that, right? By the time we filed the defense and counterclaim, the client had paid about 15,000, 20,000. Then when we were going for pre-trial conferences, maybe he was out of pocket by about 25,000 by that stage. Or maybe 30,000, I'll tell you why, because the other party had asked for further and better particulars, which is a complicated 56 questions that we had to answer, and so we had to do a lot of things. And then we went to mediation. Okay? And the mediation for a day, it could be about 10,000 shared between the parties, the cost. That's it. Okay, but we had to go through litigation and all that. But I've had matters where the other party had made a claim against my client for 250,000, right? And because I knew the other party's lawyers, before they even commenced court proceeding, they said, "Can we go mediate?" I said, "Yes, let's go." Okay. So by that time, there was a letter of demand, and there was a reply to the letter of demand, which cost my client maybe about 6,000 or so, right? And then we went to mediation. My client paid another 4,000 for the day in mediation and we settled. Right? So you're talking about 15, 20,000. And that's before proper court proceedings took place. Right? Now, in that particular matter, it's very interesting because I already learned the skills of mediation and all those things, and I knew who my opponents were. I told my client $250,000 claim. I said 4 o'clock today we will settle at 25,000. And he said, I don't get it. So we went into mediation, and there was a part where at 11 o'clock, and I knew the mediator as well. 11 o'clock, mediator comes to me and says, so your client want to pay 80,000 now. And I walked back towards my client and I said, I'm going to tell you something. I know you're going to get angry, and this is what they want. Then he said, what? Where? I got money? Blah, 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 and all that. 12:30, the mediator comes to me and says, so how your client can pay 60,000 now? So I went and sat next to my client, and my client said, so what's happening? I said, wait lah. Then my client and the mediator is waiting for us there. Then after about 5 minutes, he says, so what's happening? Tell me what's happening. He said, wait lah. Then at 12:40, he's getting irritated. Hey, Anil, the mediator talked to you, right? So what is it the mediator wants now? How much is he asking for? I said, it's lunchtime. Let's go and have lunch. Relax. Everybody's got lunch. And we'll be sitting together. Don't worry about it. 2:30, we went back in. Before you know it, by 4 p.m., we were down to 25,000 and settled. Right? But that was a matter where we didn't go to trial. So therefore, he didn't incur all of the costs. So when you ask me this question, sometimes the answer to the questions that you ask, it all depends. So like the one on fraud, there's a criminal element, there's a commercial element. So the answers all depends, you see. So I can't give you a structured idea. Maybe this last point here. I was in Sri Lanka about 5 years ago, and I was speaking to a developer, and the developer was saying how he's going to go into an arbitration with another developer, and it's going to be costly, and whether there's another way. Now, arbitrations in Sri Lanka are long, 3 years, 4 years kind of thing. Then I said, yeah, mediate. So he asked me, what's mediation and blah, blah, blah. Then he says, okay, sounds interesting. So how much is it a day? Then I said, maybe about 10,000 US dollars a day. Then he jaw dropped. Then he slowly whispered and said, so how long would that take, huh? Then I said, a day or two. His eyes just lit up. And he was in shock. He said, seriously? I said, yeah. If you give it to me, I should be able to wrap this up in a day or two. Then he said, so 2 days, that means 20,000 US dollars and we're done. I said, yeah. It's been 4 years since. He's still in arbitration. He's still the only person who's smiling from here to eternity is his lawyers, because they're nowhere near settling the matter, right? So therein lies the fact about how cost works and which way it works, all right?
Right. Yes. Okay. Yeah, thank you for that. I think there's one last question. I don't see anything on the Q&A, but let me just ask this one last question, and then I think we can close this evening's webinar. I just wanted to touch on collaborative and alliance contracting, right? That's quite an interesting concept. And Arnold, you mentioned that the premise to that is really about, doing the right things and coming to a balanced view of risk. Now, I imagine that might be tricky because, humans and entities and companies, I would say most are naturally selfish. They want to protect their own interests. So in collaborative and alliance contracting, how does one come to the table and create that balance when at the base, people are wanting the best deal for themselves and wanting to protect their interests to the maximum? How does one navigate that?
Now, for your industry, the where you deal with brokers and all that, right? It's at the moment close to impossible because they are brokers who have got a technical skill and they're providing you a service. So how to balance that and balance the risk is really quite a tricky situation at the moment. I say at the moment because it's not insurmountable. I'll tell you why I say at the moment. I started speaking about collaborative contracting 10 years ago. Right, and I preached about it at major construction industry events and all that. And where are we now 10 years later? We are coming right exactly bang on to this. I started speaking about and then wrote papers in the Asian Journal of Mediation on online dispute resolution in 2016, my first paper, and 2019, my second paper. Guess where we are headed to now? Online dispute resolution. All right. So it's not insurmountable for your industry, but let's now take it to the construction industry. Very simple. We come out of the pandemic. I am 2 years behind time in getting my retail mall up and running. I'm desperate for it to be finished up. You're a contractor. You're desperate for work. You have problems with employment workers and all of those things. We come to the table. My interest, no longer position, is to get my job done in 2 years. You tell me that you and I are not going to make compromises and adjustments. You tell me that I'm going to treat you like a typical contractor, subcontractor, that means your problem. No way, because I need my job done. You need assistance in getting the manpower allocation, getting the resources up and running, adding workers to the site, and all of those things. It is definitely the only way forward is collaborative contracting. Right? So in the construction industry, it works. But whether that works in the investments and in all of that, no, because well, it could to some extent. The brokers want money, they make commissions off their deals and all of that. You're not ready to do that because coming out of the pandemic, you're in a bad state, right? So you may have some bargaining power in terms of the contract that you enter with me as I'm the broker. But what the bargaining powers are is like you could turn around and say, no, I'm not really interested. But sir, you got a lot of money, at the moment. Why don't you park it? No. I don't want another pandemic you don't want another pandemic to take place. You don't want this thing. So, okay, what if I make adjustments to the contract that is more favorable to you and so on and so forth? So you find people starting to negotiate that. Now, today, we negotiate a deal like that. Tomorrow, my fellow broker negotiates another deal like that. Before you know it, in a year or so many of my brokers have negotiated a deal that's more collaborative in nature, more alliancing between the broker and the investor. And before you know it, it becomes a norm, right? And that's it.
Okay, great. Thank you so much, Anil, for your wisdom and all those great war stories. And I think it's really inspiring that you believed in the way things can be, certainly in the legal landscape, and you've certainly pressed on in your convictions. That's really very inspiring. Well, everyone, we've come to a close for this evening's webinar. Hopefully, you've taken something out from today, either for your personal situation or a situation that you've encountered or you may encounter in the future. And as Anil has said, nothing is all set in stone. He's actually managed to shift certain things which were not before into something that is of today. So that gives us a lot of hope. And at the end of it, I think if we think along interest rather than position, perhaps that principle really would move us towards coming to better agreements, better resolution on matters of dispute, whether in business or even in family life, right? So with that, thank you everyone who has dialed in and for being on time. If you've got anything that you need to, reach out to Anil for, even for real stuff, his contact details are there, his notes are there. So certainly you reach out to Anil. As I said, there are very, very few lawyers whom I would dare to say publicly are ethical and do things right, but I think Anil is certainly, to me, one of the few, right? So thank you, Anil, for your time, and thank you everyone for joining this webinar. Yeah.
Thank you. Good night, everyone.